I really deeply appreciate the opportunity to take part in this celebration of the life and work of Justice Jackson, and among other things, it gives me a chance to acknowledge publicly my own debt for one of the great experiences of my life. I first met Justice Jackson in the winter of 1943 when I was still in law school. And I received a letter from him inviting me to come to Washington to be interviewed for a possible clerkship with him. The process of selecting Supreme Court law clerks was much less elaborate in those days than it is today. Most of the justices used some law school professor or some appellate judge to recommend a law clerk to them. And it's very different today. Supreme Court law clerks almost invariably come from the ranks of Court of Appeals clerks, and it's become very complex and competitive. I'm told that applicants nowadays may spend weeks preparing for an interview with a particular Supreme Court justice, much like preparing for a bar exam. Well, happily for me, I never went through that. It happened that a classmate and good friend of mine was William Jackson, the justice's son. And Justice Jackson, I believe, had discussed the matter with Bill. So I went down and had a very enjoyable conversation with the justice, and of course accepted his invitation on the spot. Many years later, I had the opportunity to introduce Justice Jackson to an outstanding student of mine at Stanford Law School, who I thought would make a good law clerk for him. And I don't think the justice hesitated very long that time either in deciding to take the student as one of his clerks for the next term. By that time, there were two. There was only one in my time. That student, by the way, was William Rehnquist. And my impression is that Justice Jackson never agonized very much over selecting a law clerk. As with so much else in his life, he acted with a sure sense of his own judgment and a willingness to risk being wrong. This was also another manifestation of the self-reliance that was one of his, I think, strongest traits. He kept framed on his mantelpiece a rendering of Kipling's line, "He travels the fastest who travels alone." The truth is that Justice Jackson didn't really need a law clerk. True. Justice Jackson's ordinary working procedure was to produce a more or less finished draft of an opinion and give it to the law clerk with an invitation to comment. And you learned pretty quickly to be as prompt as possible if you wanted to make any suggestions or comments on an opinion. And because once he was pretty well satisfied with his own draft, he was quite anxious to get the reactions of other members of the court. So he would likely say, well, that's a pretty good point, but let's get the draft printed up and shoot it around and see what the others say. And then, of course, if, as fairly often happened, he got 4 concurrences, he would say, well, let's not rock the boat now. I suspect that he discovered early on that he had a gift for graceful and vivid expression and used every opportunity to cultivate it. Certainly there was never anything strained or studied about his composition, and the easy flow of his prose, striking analogies, aphorisms, paradoxes, and antitheses were so much a part of all his writing that isolated examples can't convey the full impact of his writing style by any means. One simple example, he began one opinion by saying, "We granted certiorari, and in this court the parties changed positions as nimbly as if dancing a quadrille." Square dancing was one of his pastimes, as was horseback riding. In another opinion, speaking of bribery, he said, "Men are more often bribed by their loyalties and ambitions than by money." A characteristic aphorism. He could be at his best when he turned his wit on himself, as in disowning a prior position. To quote, "Except for any personal humiliation involved in admitting that I do not always understand the opinions of this court, I see no reason why I should be consciously wrong today because I was unconsciously wrong yesterday." And as that quotation shows, he was not averse to sardonic comment on the opinions of the majority. In another dissent, he said, "I do not know whether it is the view of the court that a judge must be thick-skinned or just thick-headed, but nothing in my experience or observation confirms the idea that he is insensitive to publicity." Or again, "The court's reasoning adds up to this. The commission must be sustained because of its accumulated experience in solving a problem with which it had never before been confronted. I give up." He was most eloquent, however, when his prose was put at the service of fundamental values. The inspirational power of his statements was comparable, seems to me, to the wartime speeches of Winston Churchill, with whom he had a number of other traits in common, I think. Memorable examples are his opinion for the court in the flag salute case and his dissenting opinion in Korematsu, the Japanese relocation case, and of course his opening and closing addresses to the War Crimes Tribunal at Nuremberg, which I must say have made available to anybody who is interested all the essence of the massive record of the Nazi crimes that the Nuremberg trial created. As he liked to point out, he was probably the last Supreme Court justice there would ever be who received his legal training primarily by apprenticeship rather than formal study. And one cannot help wondering whether his style of thinking and writing about the law would have been different if he had been the product instead of intensive law review training. Of course, it's idle to speculate about that, and it might be more useful to ask how students of today might be stimulated by his example. I've sometimes thought that one of the underdeveloped uses of the case method is its potential for cultivating good taste in legal literature. What a superb addition to one's legal education might be obtained from simply reading and analyzing scores of opinions by Judge Cardozo, or Learned Hand, or Henry Friendly, or Robert Jackson. And so in conclusion, I leave you with the thought, might not the Albany Law School do well to initiate such an experiment by offering a course or seminar devoted entirely to the opinions of Robert H. Jackson? It would be a fitting tribute, I think, to use his own works to provide the kind of experience that he evidently received from that splendid teacher, Mary Willard. And I'm sure it would give law students much pleasure, as I have found anew in rereading familiar opinions in preparation for this evening. That's part of the reason why I'm grateful to have had the opportunity to participate in this event. Thank you very much. Wonderful.